Okay, let's imagine this scenario. You've got this important patent application, everything's ready to go, but then, bam, the inventor who needs to sign the oath or declaration, suddenly not available.
Yeah, that happens. Maybe they're unreachable or legally can't sign.
Or maybe they just flat out refused. Does the whole thing just grind to a halt?
Well, it could be a huge problem, but luckily the patent system actually has ways to handle situations like that.
And figuring out how the system deals with that. That's exactly what we're diving into today. Welcome back to our deep dive into the Manual of Patent Examining Procedure, the MPEP.
Yep, another session unpacking a specific piece of the MPEP. The goal, as always, is to help you get a clearer handle on U.S. patent practice, one section at a time.
Today, our focus is MPEP, Section 604. Now, this is tucked away in Chapter 600, which covers parts, form, and content of application.
And Section 604 itself, it's called substitute statements.
Substitute statements. Okay, so this lays out the rules, the whole legal framework for using one of these instead of the inventor's normal oath or declaration.
Exactly. It's crucial context, though these specific rules in Section 604, they apply only to patent applications filed on or after September 16th, 2012.
Ah, okay, so we're firmly in the post-AIA landscape here. Before that date, different rules applied.
That's right. And this whole setup is governed by the Regulation 37 CFR 1.64.
Which puts the law, 35 U.S.C. 115 dade, into actual practice.
It really shows you the system trying to be flexible, right? Trying to keep things moving, even when the perfect scenario, the inventor just signing, isn't possible.
Okay, let's really unpack this then. Our mission for this deep dive.
Yeah.
Figure out exactly when you'd actually need a substitute statement, pin down who has the legal green light to sign one if the inventor can't or won't, and get specific about what info absolutely must be in that statement for the patent office to accept it.
So yeah, the big question first. Why would you ever need this substitute thing instead of just getting the inventor's signature? The MPP is very specific here. It lists the only situations where it's allowed.
Only these specific ones. You can't just use it for convenience.
Nope, definitely not. It's strictly limited to the circumstances laid out right there in MPP Section 604. So first one, the inventor is deceased.
Okay, pretty straightforward. They obviously can't sign.
Exactly. Second situation, the inventor is under a legal incapacity. Meaning they're legally unable to sign documents for themselves, maybe due to age or some kind of court determination about their capacity.
Right. And the third case?
The third is if the inventor just cannot be found or reached. But, and this is key, despite diligent effort.
Diligent effort. That jumps out. Sounds like you can't just, send one email and give up.
Absolutely not. You really have to try. Now, the MPP text itself doesn't spell out exactly how you prove that diligent effort under this specific section, Section 604, but the implication is clear.
You need records.
You need to make reasonable attempts to find or contact them. And yeah, you absolutely should document those attempts. Keep records. That could be vital if someone questions it later.
Makes total sense. Cover your bases. Okay, what's the last situation for using a substitute statement?
The fourth one is simply if the inventor has refused to execute the oath or declaration.
So they're alive, capable, reachable, they just won't sign.
Exactly. For whatever reason, they're unwilling.
Okay. So if one of those four things happens, death, incapacity can't be found, or refusal and the inventor isn't signing, who can step in? Who's got the authority? This feels pretty critical.
It is critical. Authority is everything here. The rules are clear about who can sign, and it really hinges on who the applicant legally is in that specific case.
Right.
So the authorized signers can include a legal representative, think executor of an estate for a deceased inventor, or a guardian for someone legally incapacitated.
Okay.
And this actually ties back to another rule, 37 CFR 1.43, which talks about legal reps filing applications and points right over to Section 1.64 for these substitute statements.
Got it. So legal rep is one option. What about co-inventors? Can they sign for each other?
Sometimes. A joint inventor can sign in certain situations, but not always. And the other big category is an assignee.
The owner of the invention rights.
Right. A party who has acquired ownership rights, they have a proprietary interest. They can be authorized too. And this connects to 37 CFR 1.46, which covers assignees filing applications, again, for inventions post-September 16th, 2012.
Okay, let's walk through a couple of examples maybe. What if you have, say, 3 inventors and just one of them refuses to sign?
Good scenario. If you have multiple joint inventors listed and only one refuses, the other joint inventors can execute the substitute statement for the one who refuses.
Ah, okay.
But there's a condition. Those remaining inventors need to collectively be the applicant under the definition in 37 CFR 1.45. If they are, they can essentially cover for the unwilling inventor.
Okay, but you said joint inventors can't always sign for a co-inventor. When is that situation?
Right, that's a really important distinction. Joint inventors cannot sign a substitute statement for a co-inventor who is deceased or legally incapacitated.
Ah, so refusal is different from death or incapacity.
Exactly. In those cases, death or incapacity, it has to be a legal representative, or if the rights were assigned, it has to be an assignee applicant following Rule 1.46. The other inventors can't just sign for them then.
Interesting distinction. Refusal, the team can handle it. Death or incapacity needs someone with formal legal authority or ownership.
Precisely.
What about tricky ownership? Like, say, two different companies co-own the invention as assignees.
Yeah, that happens. In those complex ownership situations where you have multiple assignees who together make up the applicant, all of those assignees have to jointly execute the substitute statement.
So one co-owner can't just sign for everyone.
Nope. They all need to be on board and sign together.
All right, that clears up the who can sign part. Now, what about the statement itself? What actually needs to be in it? It can't just be a signature, right?
Definitely not. It's a formal statement, and to be legally valid, it has to affirm certain specific facts. It's not just filling in a blank.
Okay, what are the must-haves?
Well, first, it has to clearly state the reason the inventor couldn't or wouldn't sign. Was it death, refusal, couldn't be found? You have to specify.
Makes sense. What else?
It needs to identify the inventor or inventors that the statement is about. It also has to clearly identify the person who is signing the substitute statement.
Right.
And crucially, it has to state their relationship to the inventor. Are they the legal rep, an assignee, a joint inventor signing because of refusal? That relationship needs to be stated.
So it explains the whole context, the why and the who of the situation. Does it also need to meet the standard requirements for any inventor's oath?
Yes, good point. It still has to comply with the general requirements for oaths or declarations that are laid out in 37 CFR 1.63.
And I think I saw something about an ADS.
Right, the application data sheet. Often information required by these rules can just be included in the ADS, according to 37 CFR 1.76. It's basically a standard form used in filings to consolidate information. Makes things a bit easier.
Okay, now what about proof? If you say the inventor refused or you couldn't find them, do you have to attach, like, affidavits or evidence with the substitute statement when you file it?
That's a really practical question. The answer is generally no. You don't need to submit formal proof like a death certificate or detailed search records with the statement itself when you file.
Okay.
However, and this loops back to what we said earlier, the non-inventor applicants who are signing should absolutely maintain their own records, especially for the diligent effort or refusal situations. Keep records of the emails, the letters, the attempts made.
Because it could come up later.
Exactly. If the validity ever gets challenged, having those records could be crucial. So, best practice. Keep meticulous records even if you don't submit them upfront.
Solid advice. Okay, last piece here. The legal weight of this document. Signing the substitute statement, it sounds like it's a serious commitment.
Oh, absolutely. It's not casual at all. The person signing takes on significant responsibility. They have to acknowledge that making false statements is punishable under federal law, 18 U.S.C. Section 1001. We're talking potential fines, even imprisonment.
Wow, okay. So it carries the same legal punch as a regular oath.
It does, and it goes further. The person signing must confirm they've actually reviewed and understood the entire application contents.
The whole thing, including the claims.
Yes, including the claims. They can't just sign blindly. They need to know what they're signing off on.
And what about the duty of disclosure? Informing the patent office about prior art and stuff.
That too. They must be aware of and comply with the duty to disclose all material information to the USPTO, just like an inventor would. That's under 37 CFR 1.56. It's that fundamental duty of candor and good faith.
So signing a substitute statement really means stepping into the inventor's shoes, legally speaking, for these core responsibilities.
Pretty much, yeah. It ensures the integrity of the whole process is maintained, even when the inventor themselves isn't the one signing.
Okay, so let's wrap this up. What's the big picture here? MPPP Section 604, working with its rules like 37 CFR 1.64, it gives these really vital, specific ways for patent applications to keep moving forward. even when getting the inventor's signature on the oath isn't possible.
Right. It clearly lays out those limited situations where you can use a substitute statement. It specifies exactly who has the authority to sign based on their legal role or ownership, and, importantly, it keeps the process robust by demanding specific information in the statement and making sure the signer understands their serious legal obligations.
Including that crucial duty of disclosure.
Definitely.
And just one last reminder for everyone listening. This specific procedure we've been discussing under MPP Section 604. It's for applications filed on or after September 16, 2012.
And before we sign off, a special thank you is definitely due to Mike Shepard, the creative director who organized this whole MTP audio series.
Yes, thank you, Mike. And our usual disclaimer, please remember this summary of the MPEP was put together using AI tools. It might have errors or omissions. It's really for general educational and informational purposes only.
Absolutely. It's not legal advice, not a substitute for proper instruction. For the definitive word, always consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
You know, looking at this section, it really highlights how a complex legal system like patent law has to build in ways to deal with messy real-world situations, things like death, incapacity, or even just someone refusing to cooperate.
It does. It makes you appreciate these fail-safes, as you called them earlier. Provisions designed to make sure important processes don't just collapse when things get complicated. It's this balancing act, right? Balancing the inventor's rights and role with the practical need to actually move an invention through the system.
So thinking about that balancing act and those fail-safes, what particular aspect of the substitute statement rule stands out most to you as effectively handling those tough scenarios?